My name is Dessa Moreland. I am 37 years old, a licensed occupational therapist in the state of Tennessee, and I was sitting in my car in the parking garage of the Shelby County Probate Court in Memphis on a Wednesday morning in April when my attorney called and said, "Dessa, they found the video." She did not say anything else. For a moment, she let the sentence sit, the way attorneys let sentences sit. When the sentence has done something that does not need improvement. I said, "The whole thing?" She said, "The whole thing." Timestamped it 14 minutes and 32 seconds. I put my hand flat on the steering wheel. I looked at the concrete wall of the parking garage. I thought about my grandmother, whose name was Eunice Marie Tillman, who had made sweet potato pie from scratch every Thanksgiving and kept her important papers in a green metal lockbox under the bed in the guest room, and who had died in January at the age of 86, believing, as far as I know, that she had done everything right. She had done everything right. The problem was that my sister had done everything wrong and had been careful about it and had not been careful enough. This is the story of what a notary's Ring doorbell camera saw on a Sunday afternoon in December, 6 weeks before my grandmother died, and what that footage did to a forged signature on a codicil to a will. I need to give you Eunice first, because this story does not make sense without her. Eunice Marie Tillman grew up in Byhalia, Mississippi, the third of 7 children of a Baptist minister named Elmore Tillman and his wife, Ruth. She had moved to Memphis in 1958, married my grandfather James Tillman in 1961, and spent the next 40 years working as a seamstress and alteration specialist at a department store on Union Avenue, while James worked at the Buckeye Cellulose plant in North Memphis. They saved with the particular focused discipline of people who had grown up with nothing and understood that nothing was always closer than it looked. When James died in 2003, Eunice owned their house outright. A 3-bedroom brick house on Snowden Avenue in the Midtown neighborhood of Memphis, bought in 1967 for $22,000 and paid off in full by 1991. She also had a savings account at Triumph Bank with a balance that, when she died in January, had reached $94,000, accumulated across 40 years of working, saving, and refusing to spend money on things she did not consider necessary. She had 2 grandchildren, me and my sister Tara. Tara is 41 years old. She lives in Memphis, 7 minutes from the Snowden Avenue house, a proximity that was a geographic fact for most of our lives and became a strategic one in the last 3 years of Eunice's life. As Eunice's health declined, Tara was present. She drove Eunice to appointments, she brought groceries, she sat with her on Sunday afternoons. I am not going to pretend that none of this happened, or that it did not matter, because it happened and it mattered, and Eunice loved Tara for it. I live in Nashville. I drove to Memphis every 6 to 8 weeks. I called 3 times a week. I sent money when Eunice needed the water heater replaced, and again when the HVAC unit failed in the summer of 2022. I was present in the ways available to me across a 3.5-hour drive, which are real ways, but are not the same as being 7 minutes away. I have made peace with this. What I have not made peace with is what Tara decided to do with her proximity. Eunice had a will. She had executed it in 2009 with an estate attorney in Memphis named Franklin Greer, at Greer and Associates on Poplar Avenue. The 2009 will was clear. The house on Snowden Avenue and the savings account at Triumph Bank were to be divided equally between Tara and me. Equal shares, equal treatment, 2 granddaughters. The way Eunice had always operated. She had told me about the will in 2009 and again in 2019 when she updated her beneficiary designations, and again in 2021 when I asked her directly because I wanted to make sure everything was in order. She said, "Dessa, it's equal. It's always been equal. Don't worry about it." I said, "I'm not worried, Granny. I just want to make sure you've got what you need." She said, "I've got what I need, and you'll get what's yours." That was the end of the conversation. What I did not know was that in December of the year before she died, someone had added a codicil to that will. The codicil was 2 pages. It amended the distribution of the Snowden Avenue house, removing my name as a beneficiary and replacing it with Tara's name alone. The savings account was left as originally written, equal shares. But the house, which Franklin Greer had estimated in 2022 at a market value of between $310,000 and $330,000, was redirected entirely to Tara under the terms of the codicil. The codicil bore my grandmother's signature. It also bore, on the notarization block at the bottom of page 2, the stamp and signature of a notary public named Renee Alcott, commission number 792214, commission expiring March 2026, address listed as a residential street in Bartlett, Tennessee. The codicil was dated December 11th. I did not know any of this until the probate filing in February, 6 weeks after Eunice died. When Franklin Greer's office called me to say they had received a filing from an attorney representing Tara that included an amendment to the estate documents I needed to review, I drove to Memphis on a Friday. I sat in Franklin Greer's conference room. He set the codicil on the table in front of me. He was 63 years old and had been practicing estate law for 31 years, and he had the expression of a man who had seen this particular configuration before and found it no less unpleasant for the familiarity. He said, "Dessa, I have to ask you some questions before we go any further." I said, "Ask them." He said, "Were you present on December 11th when this document was executed?" I said, "I was in Nashville on December 11th. I can show you my clinic schedule." He said, "Did you have any knowledge of this codicil before today?" I said, "No." He said, "Do you recognize the signature on line 4 of page 2? I looked at line 4 of page 2. Line 4 of page 2 was the witness signature line, the witness to my grandmother's signature on the codicil. The name typed beneath the signature line was Dessa L. Moreland. The signature above it was not mine. I looked at it for a long time. I had been signing my name since I was 6 years old. I knew the slope of my D and the loop of my double S, and the way my L sat between them, and the particular habit I had developed in graduate school of extending the tail of the D into a thin underline beneath the rest of the letters. The signature on line 4 of page 2 had none of those things. It was a version of my name, written by someone who had looked at my signature on something else and tried to copy it without understanding what made it mine. So, I said, "Franklin, that is not my signature." He said, "I suspected as much." He said, "I want to refer you to someone." The someone was my attorney, whose name is Patricia Okafor, a litigation partner at a firm in Memphis called Okafor and Bryce. Patricia had been doing estate litigation and civil fraud work for 18 years. She was precise in the way of people who are paid for precision, direct in the way of people who do not believe that directness requires apology, and, as I discovered over the following weeks, gifted at finding things that other people believed were not findable. The first thing she told me was that we needed to locate Renee Alcott. Renee Alcott, commission number 792214, was a notary public who had been commissioned in Shelby County in 2022. Patricia's paralegal found her in the Tennessee Secretary of State's notary database in 40 minutes. She lived on a residential street in Bartlett, in a house she had purchased in 2019. She worked as an office manager at a pediatric dental practice on Stage Road. She had no prior legal history. She was, by every available measure, an ordinary private citizen who had taken the Tennessee notary exam, paid the application fee, received her commission, and had at some point found herself in a situation she had not fully understood the consequences of. Patricia sent a process server to Renee Alcott's house on a Monday. Renee Alcott called Patricia's office at 8:17 the following morning. She said she needed to talk. I was not in the room for that conversation. Patricia told me about it in detail afterward, the way she told me about all the significant developments in measured sequential order without editorial emphasis, because she believed that information delivered without theatrical weight was information that could be acted upon clearly. She told me that Renee Alcott had been contacted by Tara in November through a mutual acquaintance. She told me that Tara had told Renee that she needed a notary for a family document, that the document was a simple amendment to her grandmother's estate plan, that her grandmother was elderly and housebound, and that the signing would happen at the grandmother's house. She told me that Renee had agreed and had gone to the Snowden Avenue house on December 11th. She told me that when Renee arrived at the house, only Tara was present, that Eunice was not there, that Tara had told Renee that Eunice had already signed the document at the kitchen table and had gone to lie down because she was tired, that Tara had presented the two-page codicil with the signature already on the grantor line and had asked Renee to notarize it. She told me that Renee Alcott had notarized the document. And then she told me what Patricia had found. Renee Alcott lived on a residential street in Bartlett. The house next door to Renee's had been owned since 2021 by a couple who had installed a Ring Video Doorbell Pro on their front entrance, a model with 1080p HD recording, a 160-degree field of view, and motion-activated continuous recording that stored footage to the cloud via a Ring Protect Plus plan at $10 a month. The camera faced the street. The street was narrow. Renee Alcott's driveway was visible from the neighbor's front door. On December 11th, at 2:47 in the afternoon, the Ring camera recorded Tara's car, a white Nissan Altima with a Shelby County plate that Patricia's paralegal had already identified from Tara's vehicle. Registration, pulling into Renee Alcott's driveway, the footage showed Tara getting out of the car. It showed her going to the front door. It showed the door opening. It showed her going inside. 14 minutes and 32 seconds later, it showed her leaving. It showed her getting back into the white Nissan Altima. It showed her driving away. The timestamp was December 11th. The time was 2:47 to 3:01 in the afternoon. Eunice Tillman's house on Snowden Avenue was 23 minutes from Renee Alcott's house in Bartlett. Tara had not gone to Snowden Avenue on December 11th with a notary to witness Eunice signing a document. Tara had gone to Renee Alcott's house in Bartlett to have a document notarized that Eunice had not signed in Renee Alcott's presence because Eunice had not been at Renee Alcott's house. Eunice had not been there because Eunice was 23 minutes away on Snowden Avenue, and the signature on the grantor line of the codicil was not Eunice's. And the signature on the witness line was not mine. And the notarization stamp at the bottom was real but applied to a document that had been executed through fraud. I want to stop here because what I just described to you is the mechanics of what happened, the camera footage and the timestamps and the 23-minute drive time, and I have described it in the flat procedural language it deserves. But I want to tell you what it felt like to sit in Patricia Okafor's conference room on a Tuesday afternoon in March and watch 14 minutes and 32 seconds of Ring doorbell footage on a laptop and see my sister's car pull into a notary's driveway. I had known Tara my entire life. I had shared a bedroom with her for 9 years on the south side of Memphis. I had been at her wedding in 2008 and at the hospital when her daughter was born in 2010. I had driven to Memphis when she called me in 2017 and told me her marriage was ending, and I had sat with her in her apartment for 3 days, and I had not once in that time thought about anything except being her sister. She is the person who taught me to ride a bike and who told me the truth about a boy I was dating in college who was not worth my time and who called me from the hospital parking lot when Eunice fell and broke her hip in 2021 because she knew I needed to know before I heard it any other way. She is also the person on the Ring camera footage getting out of the white Nissan Altima at 2:47 in the afternoon, with a forged document in her hand. I do not know how to hold both of those things at the same time. I have been trying to hold them since March. I have not yet found the way. What I found instead was Patricia Okafor. And Patricia Okafor found the footage. And what happened after the footage is what I am going to tell you now. Patricia filed a formal objection to the codicil in Shelby County Probate Court in April. The objection was supported by 4 attachments. The Ring doorbell footage, downloaded from the cloud account by the neighbor, a retired postal worker named Gerald Fitch who had been cooperative without reservation from the moment Patricia explained what she needed and why. An affidavit from Renee Alcott, who had retained her own attorney and was cooperating fully with both the estate proceedings and a separate matter I will describe shortly. A handwriting analysis report from a forensic document examiner named Dr. Carolyn Spite at Spite Forensic Document Services in Nashville, who had examined the codicil signatures and produced a written opinion finding that the signature on the grantor line was not consistent with Eunice Tillman's known signature samples and that the signature on the witness line was not consistent with my known signature samples and my clinic schedule from December 11th, which showed 3 patient appointments in Nashville the last one ending at 4:30 in the afternoon, a schedule I had produced in 2 minutes from the scheduling software at my practice. The probate court set a hearing date. I also want to tell you about Renee Alcott, because she is part of this story and her part of it matters. Renee Alcott had not known she was participating in fraud. This is what she told Patricia, and what she told her own attorney, and what she told the investigator from the Tennessee Secretary of State's office who reviewed her notary commission in April. She had been told the document was legitimate. She had been told the grandmother had signed it. She had been a notary for 2 years and had notarized car title transfers and employment forms and sworn statements and had never been in a situation like this one. When the process server appeared at her door, she had, Patricia told me, been visibly frightened and then visibly relieved, in the way of people who have been carrying something they should not have been carrying and are glad to be asked to put it down. Her notary commission was suspended pending the Secretary of State's review. She cooperated with the probate proceedings in full. The Shelby County District Attorney's Office opened a case. The probate hearing was on a Wednesday in April. I was there. Patricia was there, Franklin Greer was there, Tara was there with her attorney, a man named Clifton Morse, who had filed 2 pre-hearing motions, attempting to have the ring footage excluded on the grounds that it had been obtained from a private residential camera without Tara's consent. The probate court denied both motions. Gerald Fitch had provided the footage voluntarily from his own camera on his own property. There was no legal mechanism by which Tara's consent was required. The codicil was invalidated. The probate judge, a woman named the Honorable Diane Carver, who had been on the Shelby County Probate Court for 11 years, ruled from the bench. She said the ring camera footage established that the notarization had not been performed in compliance with Tennessee notary law, which requires the notary to witness the signature of the principal in person at the time of signing. She said the forensic document examination raised substantial and unrebutted doubt about the authenticity of the grantor's signature. She said the codicil was therefore void and of no legal effect. She said the 2009 will of Eunice Marie Tillman, as originally executed by Franklin Greer, would govern the distribution of the estate, equal shares, the way Eunice had always intended. I stood outside the probate court in the April morning, and I felt something that I want to describe accurately because I think it matters to describe it accurately. I did not feel triumphant. I am not built for triumph the way some people are. Built for it, with their arms out and their chins up. What I felt was the specific grief of a thing that should not have needed to happen, happening correctly. It had happened correctly. It had come out the way it was supposed to come out. And the reason it had come out that way was a Ring Video Doorbell Pro on a neighbor's house in Bartlett and a retired postal worker named Gerald Fitch who had said yes without hesitating, and a notary who had been frightened enough to tell the truth, and a forensic document examiner in Nashville who had spent 40 years learning to see what the eye could not see on its own. The district attorney's case is ongoing. I am not a party to it. It is a criminal matter, and the criminal matter is the state's concern, not mine. I have been told by Patricia not to discuss its specifics publicly, and I am not going to. What I will tell you is that it exists, and that it is proceeding. I drove back to Nashville after the hearing. Patricia called me at 4 o'clock to walk me through the next steps in the estate administration. The Snowden Avenue house needed to be inventoried. A real estate agent was going to be engaged to assess market value for the purpose of the equal distribution. The Triumph bank account would be divided according to the original will. Franklin Greer's office was handling the mechanics. It was going to take several months. Estates always take several months. That is the nature of estates. I sat on my back porch that evening in Nashville with a cup of coffee and thought about my grandmother. I thought about the green metal lockbox under the guest room bed where she kept her important papers. I thought about the last time I had seen her, in December, 3 weeks after December 11th, when I had driven down for her birthday. She had been well that day, or well enough. The way she had been well enough for the last 2 years, present and sharp in her mind, but slower in her body, sitting in the chair by the front window where the light came in from the west in the afternoon, the way she liked it. She had made sweet potato pie for her own birthday because she did not trust anyone else to make it correctly. A position I had always found both exasperating and entirely consistent with who she was. We had sat at the kitchen table and eaten sweet potato pie on paper plates, she and I, because she said good plates were for company, and I was not company. I was family, and the distinction mattered. She had talked about the garden she was planning for spring, the one she planted every year in the narrow side yard, the one she had been planting in the same narrow side yard since 1968. She said she wanted to try a different variety of collard this year. She said the one she had grown last year had been bitter by August, and she blamed the seed and not herself. She did not seem like a woman who had signed a document 6 weeks earlier, redirecting the most significant asset of her estate away from one of her two granddaughters. She did not seem like a woman who had made that decision and told no one. Not Franklin Greer, not me, not her pastor, not a single person in her circle of trust that had not contracted in her final years to include essentially Gerald Fitch next door and the women in her church's Tuesday morning Bible study. She seemed like a woman who had done everything right and expected everything to come out right, the way she had always expected things to come out when she had done everything right. With the earned confidence of a woman who had paid off a house in Memphis in 1991 on two working-class salaries and kept $94,000 in a savings account at Triumph Bank through 4 decades of wanting things she chose not to buy. She was right about everything. She had done everything right. The rest of it was not hers to carry. I have not spoken to Tara since the hearing. I do not know when I will. Patricia has advised me to let the estate administration conclude before I make any decisions about contact, and I am following that advice. Not because I do not have things I want to say, but because I have learned across this year that the time I spend deciding when to speak is more useful than the time I would spend saying the wrong thing at the wrong moment. My mother, who is Eunice's daughter-in-law, a position that gave her no legal standing in the estate but considerable standing in my understanding of what this year has cost, called me the week after the hearing. She did not say much. She said, "Your grandmother would have been glad you fought." I said, "I know." She said she was proud of you, the therapy work. I said, "I know that too." She said, "Okay." She said it the way my mother says, "Okay," when there's nothing further that words can do, and silence is the more honest answer. I said, "Okay, back." We sat on the phone for a moment, then we said goodbye. The estate will close in the fall, Franklin Greer estimates. The house on Snowden Avenue will be sold and the proceeds split. The Triumph bank account will be divided. Eunice's furniture, her dishes, her sewing machine, the one she had used for 40 years at the department store on Union Avenue and brought home when she retired and kept in the second bedroom on a dedicated table with a good light, will be divided between Tara and me. If we can manage that division without a mediator, Franklin Greer thinks we can. Patricia is less sure. I am somewhere between the two of them on the question. The green metal lockbox is in my possession. Franklin Greer's office asked what I wanted to do with it after the estate papers were removed. I said I wanted to keep it. It arrived in Nashville by courier on a Thursday, the original lock intact. The key, taped to the bottom in a piece of masking tape the way Eunice had kept it since 1987. I put it on the shelf in my study, next to my Tennessee OT license and my graduate degree from Belmont University. It does not contain anything. Now, it is a lockbox with nothing in it, which is a different thing from a box with nothing in it. A lockbox with nothing in it is a thing that held something important and kept it safe until it needed to be used. My grandmother understood the difference between keeping and holding. She understood it about money, and she understood it about the house, and she understood it, I think, about people, though her patience in that category was longer than mine. Has proven to be. Gerald Fitch sent me a card in May. It was a grocery store sympathy card, a simple one with a flower on the front. Inside he had written, in the careful handwriting of a man who had been a postal worker for 31 years, and understood. The written words were worth doing correctly. I am glad the camera was pointed the right direction. Your grandmother sounded like good people. I hope things come out right. Gerald Fitch. I have put it in the green metal lockbox. It fits just right,